We would now like to start the SEP Symposium by JPO Japan Patent Office 2022. I am Nishina, Director of Policy Planning and Research Division of JPO. I will be acting as the facilitator for today. Today, we'd like to proceed in accordance with the agenda announced on JPO's website. Firstly, speech from Mr. Mori, JPO Commissioner. Mr. Mori, floor is yours.
Welcome to the JPO SEP Symposium. I'm Kiyoshi Mori, Commissioner of the Japan Patent Office. I'm grateful that the JPO is able to hold this symposium at a time when SEP-related issues are being debated more actively than ever before. Today, we would like to introduce what is happening on the front lines of the global discussion of SEPs. I hope you will enjoy this event until the end. I would like to begin by giving a presentation. While a patent grants exclusive rights to a technology, a standard is designed in order to spread a technology. While both patents and standards are intended to promote innovation, there is a seeming contradiction between them that would appear to give rise to a tension. This tension first became evident during the 1990s, when telecommunication technologies started shifting to digital formats. This was accompanied by a trend toward standardizing the latest technologies while protecting them with patents, thereby resulting in SEP disputes. With the spread of the IoT in recent years, companies from a full spectrum of different industries, including automobiles, have been brought to the negotiation table for SEP licenses. As opposed to licensing negotiations between ICT companies, it is difficult to resolve disputes through cross-licensing, and such negotiations between ICT companies and companies in other industries involving divergent perspectives on essentiality and licensing rates, thereby fostering unease over SEP-related negotiations and disputes. While within this climate, the JPO published the Guide to Licensing Negotiations involving standard essential patents in an effort to enhance transparency and predictability, as well as to help prevent disputes or resolve them quickly. The JPO also began a system wherein a panel in the trial and appeal department provides an advisory opinion on essentiality with no legally binding force. When JPO's guide was first developed in 2018, attention was focused on the preliminary ruling by the European Court of Justice, CJEU, in the case of Huawei versus ZTE, which provided a framework for good faith negotiations. However, this framework did not specify detailed actions at each stage. For example, within the framework, the CJEU did not explicitly hold whether the rights holder should provide a claim chart to the implementer. On the other hand, the German Federal Supreme Court recognized in its Sisbel versus Higher decision of 2020 that the provision of claim charts is sufficient but not mandatory in terms of the information to be provided by the rights holder at the stage of licensing negotiation offer. Several court decisions attracted attention in 2020, including Unwired Planet versus Huawei before the UK Supreme Court, which decided global royalty rates, Nokia versus Daimler, which was a dispute between the ICT and automobile industry, and Conversant versus Huawei before the Chinese People's Supreme Court, which granted an anti-suit injunction. There were also many prominent court decisions after 2021, such as Optis versus Apple in the UK and the Continental versus Avanci in the US. In addition, governments have been engaging in various activities related to SEPs. A series of public consultations on policy statements and new initiatives have been commenced by the US, UK, and EU since the end of 2021, in Japan, the Ministry of Economy, Trade and Industry established the good faith negotiation guidelines for standards essential patent licenses in March 2022, which sets forth the norms of good faith negotiations to be followed by rights holders and implementers. Increasingly, active discussions regarding SEPs are taking place not only among companies that are potential parties to licensing negotiations, but also the governments of various nations. In addition to the guideline by METI, we hope that governments will provide their policies and that the direction of discussions regarding SEPs will be clarified. The JPO is now inviting public comments on the draft revision of the guide to licensing negotiations involving standard essential patents. In the draft revision, the purpose and nature of the guide are maintained as original, although recent court decisions are reflected. The consultation process lasts until the 8th of June. We are looking forward to your feedback. We would like to make this public consultation process not merely a process for revisions, but also to hold discussions with industries and experts on various issues related to SEPs. Public comments will be published, along with an explanation regarding how they have been reflected within the revised guide. We assume that the US, UK, and EU will accelerate the discussion over the result of their public consultations. We expect that the publication of our revision process will be utilized in their discussion as one of the references. Of course, we hope that the guide will be utilized over the long term by the industry as well as the lawyers. My presentation will be followed by presentations given by Mr. Kapos from the US and Mr. Hirajansky from Europe. A presentation will also be given by my colleague at METI, Mr. Hasui from Japan. In addition, panel discussions will be held on the theme of licensing practice and the effect of recent court decisions in panel 1, and essentiality check in Japan in terms of efficiency for licensing in panel 2. I hope you will enjoy this 3-hour symposium until the end. It would also be appreciated if you would give feedback through the questionnaire on our website. Thank you very much.
And going next, we would like to invite Mr. Hasui, the Deputy Director from METI, to give us a lecture. Mr. Hasui, the floor is yours. Mr. Hasui from METI, nice to meet you all. So now I'd like to explain about the good faith negotiation guidelines for SEP licenses. So this guideline, just as Commissioner Moore has explained, this March, METI has issued this is a guideline, a Japanese guideline that should be followed by SEP holders and implementers involved in SEP license negotiation, including Japanese patents. So we have invited views from industries and all the experts and have been established. So since March last year, we have been working on this for a long time. And we have invited many industrial groups, and we made a study group to discuss this matter. And as a result, last July, as I have mentioned in the process of establishing this, we have, the METI has announced that they have announced the policy of establishing and disseminating this guideline in a prompt manner. And we have conducted a hearing at the study group of the companies and also invited comments from the public. By doing so, we carefully conducted various hearings. And as a result, in February, the SEP licensing negotiation, we made some proposals, what kind of action should be taken for each steps. And at the end of March, we had announced this guideline. Going next, I'd like to explain about the background of coming up with this guideline. So the background is Looking at the domestic and overseas environment, as you can see in the blue part, from a global perspective, there are no clear rules and SEP licensing negotiations. For the companies, this means they have low predictability and transparency for the negotiations. And we have about 4 points written for the business owners. So it would pose a significant business risk. They have no predictability for the outcome of the rulings. And so there are some limits for their actions. And from the implementers, they have no predictability for the rulings outcome. So it is difficult for them to recover the legitimate price, and that would result in the delay of the process of standardization, and the continuing of R&D might become difficult. Based on this background, we have tried to improve the transparency and predictability of the court rulings. And through the good faith negotiation between the two parties, we wish to encourage the smooth settlements so that it will lead to the further development of the Japanese industry. So that was the policy announced by METI. Going to the next page. So this is what we have thought about what could be the good faith in negotiation. So we have thought about 3 ways, such as legislation or creating guidelines that are not based on legislative measures, or updating the guide to license negotiations. But in the end, among these 3, we try to promptly discuss this guideline and to disseminate this both domestically and overseas. So also we needed to have an in-depth sort of guideline. So although it is not a legislation, we decided to formulate this guideline. So as you all may know, this is for your reference. So the difference. So the SMETI's guidelines are the norms of good faith negotiations provided by the Japanese government. So I'd like to skip to the next. So so the policy of setting this guideline is. So since this guideline is established considering international trends, so we try to sort of specify what kind of actions should take by both sides, both SEP holders and implementers. And we try to refer to the preliminary rulings of Court of Justice of the European Union. So we had tried to clarify the each 4 main steps of SEP licensing negotiations and what action should taken for each steps. So we have tried to clarify what both SEP holders and implementers should do at each stages. So the SEP license negotiations is targeted for grant encumbered SEPs. So according to the step 1 to 4, we have specified what kind of action should be taken by both sides. So step 1 is on the SEP holder. So going down. So when the SEP holder makes a license offer to an implementer, the SEP holder should provide the following information regarding the patent subject to the license to the implementer, either voluntarily or at the implementer's request. That are a list of patent numbers and others, and especially the most contested issue is as the claim chart mapping patent claims to standards by each element. So regarding this claim chart, so this is something mapped with the patent claims to standards by each element. But when there is a large number of subject patents, the claim charts are made for representative patents. For this claim chart, the NDA, whether it should be under the scope of NDA or not, often this leads to a confrontation between the rights holders and the implementers. As we all know, so the claim and claim chart are also on the public information. So regarding this claim chart, it should not be included in NDA. It should be provided to the implementers. That is what we have stated. On the other hand, this claim chart, as in terms of the interpretation of the wordings, there may be some non-public information. In that case, in order to the right holders to have not to face disadvantage, then the NDA might be concluded. So by doing so, even if the right holders provide these claim charts under the scope of NDA, if necessary, the implementers can share the information with the necessary parties. So the right holder should not preclude the implementer from disclosing them to its suppliers and attorneys as other relevant parties. So even if also the implementer should not disclose them to third parties without the SEP holder's consent for purposes other than the licensing negotiations, such as publishing them on the internet. So other than licensing negotiation purpose, they should not be published. By stating these, so we try to address the concern of both the rights holders and the implementers. So this is step 2. This is the actions the implementer should take when the SEP holder has taken the action specified at step. So the implementer should express its willingness to obtain a license for the subject patent under FRAND terms. But still, even if the implementer expresses the willingness to obtain the license while reserving to challenge the essentiality, validity, or infringement of the subject patent in the negotiation process as appropriate, its willingness to obtain a license under FRAND terms in good faith is not denied. So it does not mean that the implementer has not good faith. And even after the implementer expresses the willingness, the SEP holder should not preclude the implementer from disclosing the information provided by the SEP holder to the suppliers, attorneys, patent attorneys, if the implementer needs their knowledge to proceed with its own license negotiations. So we have clarified that the SEP implementer can proceed with this license negotiation without any concern. So next is step 3 from the right holder's side, what they should do. And step 4 is what the implementer should do after the step 3. So to the implementers, when the right holders have the implementers show the willingness, then they have to show concrete methods such as the royalties and the calculation method of the royalties. And if the implementers cannot accept the proposal, then they have to make a counter proposal in terms of concrete royalties and other necessary informations. So having these kinds of provisions, we hope that the good faith negotiation will take place in SEP licensing negotiations. I hope that this will lead to revitalizing the industries. So that is all for me. Thank you very much.
Thank you very much for your presentation. We would like to proceed to the next item in the program. The title is The State of Play of the Standard Essential Patents in the US. We have Mr. David Couples, who is the former commissioner of USPTO and currently belongs to Cabas, Swain and Moore LLP. Mr. David Couples, the floor is yours.
Yes, konnichiwa and good evening. I'd like to say first hello to my many friends at the JPO. I wish I could be there with you in person, but thank you very much for inviting me to participate in this important symposium. Special hello to Commissioner Mori. Thank you for your leadership, Commissioner Mori, and for leading the JPO in continuing to address this extremely important topic of SEPs and licensing in the ICT space and beyond. So I'd like to address a few topics today, hopefully sort of setting the stage for the symposium that will come. First, I'd like to mention the backdrop, which, and thank you for the slides, you can progress to the next slide. There's a very positive economic and social value associated with SEP-based standards. And it's something that I think can be overlooked at times when we get into the machinations of discussing license negotiations. But if we step back, unlike in the past technological paradigms of the 20th century, which worked on a sort of winner-take-all model, standards-based innovation works to create ecosystems that can produce many winners: consumers, most importantly, product manufacturers, SEP licensors, and the global economy and the Japanese economy, I would say, as a whole. So today we've got consumers accustomed to global product interoperability in their daily lives: 3G, 4G, LTE, 5G, Wi-Fi, JPEG, USB are all a few of the many examples. Consumers benefit from the innovation deployed through standards. They benefit through the interoperability fostered by standardization, and they benefit from the dollar savings from competition around standards. Of course, mobile networks dramatically increasing transmission speeds while decreasing cost per megabyte of cellular data is yet another example. Empirical data over the years confirms this is an ongoing trend. There was a 2015 Boston Consulting Group report that found that mobile technologies had at that time created over 6.4 trillion with a T, annual consumer surplus, with approximately 65% of that value stemming from what at the time was the predominant 3G and 4G capabilities. There was a more recent 2021 PricewaterhouseCoopers report anticipating that in aggregate, the adoption of 5G will add some 1.3 trillion, again with a T, trillion dollars to the global GDP before 2030. So standards-based innovation clearly creates enormous consumer surplus, enormous net aggregate value. And I think we need to understand that it has created a competitive, consumer-focused innovation ecosystem that surpasses anything that existed in the world before it. So if we move forward to the next slide, SEP-based standards success is dependent, however, on a balanced ecosystem. And at the apex of this ecosystem is innovation. Value attractiveness of standards comes first and foremost from the innovation that's implemented in them. Reliance is on both licensors and licensees. Both of them have legitimate needs and interests, and both are simply prioritizing their economic interest in the marketplace. Licensors, on the one hand, invest in speculative upstream research with, frankly, limited exit options. The licensors have to invest in research while there's risk of failure in creating viable technology. There's risk of failure because the technology won't be adopted in the standard. There's risk that the standard then won't succeed in the marketplace. And the licensors absorb all of this risk. Then by opting to contribute innovation to a standard, the licensors also accept an income stream limited to royalty payments to be received, hopefully after the standard is adopted, deployed, and successful, while providing its technology, the licensor providing its technology to competitors ex ante, in other words, before the standard gets adopted. Agreeing to license on FRAND terms effectively sets an upper limit on royalties and requires disclosure of standardized technology, again, ex ante. Now, licensees, on the other hand, have capital-intensive investments that they have to make to manufacture products incorporated into standards, incorporating these SEPs and standards. Licensees also have the risk that their products won't be competitive in the marketplace, and so they have important risks that they're taking too. Both sides, it turns out, are essential to the equation and need to come to the table for productive negotiations. Now we can move forward to the next slide. There's been a fair amount of rhetoric regarding this symbiotic relationship. And over the years, concerns have been raised over SEP-based standards. But it's important to distinguish between real and perceived problems. Fears have led to, I think in some cases, especially in my own country, the US, fears have led to unhelpful policies at times that have prevented balance between licensors and licensees needed to foster innovation investments on the licensor's part and manufacturing investments on the licensee's part. And the environment, unfortunately, has weakened incentives, including innovators' incentives. As we know, in earlier generations, we had topics raised such as holdup and royalty stacking that we learned in the intervening years were not really things that were happening. Now, the data has disproved the fears and has provided us with some important empirical information. For example, since 5G's commercial introduction in 2019, aggregate royalties have not risen for the companies that are charging royalties for implementing 5G. Modest single-digit SEP royalties on smartphones have not increased in royalty terms. In fact, what the data shows is that as of around 2011, the total royalty stack, if you will, the total royalties that would be paid by a licensee were slightly under 3%. Those royalties have actually decreased from 2013 to 2014, all the way through most recent data in 2020. And as of that point, they were down closer to an aggregate royalty rate of 2%. So it turns out there's no basis, in fact, in data to views that there is some increasing royalty stack or that royalty burdens have gotten bigger, even though the capability of the standards and the products from 3G to 4G to 5G we know have gotten significantly better. Furthermore, as you can see on the chart here, concerns about rampant litigation and patent wars are also not reflected in the data. This data, of course, is US data that we're looking at, and it shows a breakdown of the litigation which demonstrates that a large percentage of suits involve only a very few players. In fact, the data shows that one company, and I'll be specific because it's all public domain data, Apple entered the field without putting licenses in place, without obtaining licenses ahead of time, and naturally wound up getting into disputes. Those disputes, just Apple's disputes, constituted over half of all smartphone patent cases between 2010 and 2012. Many matters are now resolved with in and out of court settlements, and litigation, as you can see, has been trending downward for a decade. That's the chart that you see on the left. Now, folks who are concerned about litigation rates, unfortunately, also fail in the US to adjust the data to account for the 2011 Leahy-Smith America Invents Act, which increased the raw number of lawsuits that you can see in 2011 artificially by making joinder of defendants essentially impossible, extremely difficult here in the US. So the AIA results in an actual decrease in the number of multiple defendant lawsuits and an increase in the raw number of lawsuits that masks the fact that the actual litigation rates were dropping that time, and as you can see on the chart, have continued to drop since then. So it's also the case, the data showing that SEPs are responsible for only a minority of litigation around standards like 3G, 4G, and 5G. For example, smartphone patent litigations between 2005 and 2020, the majority, that's 53%, of the smartphone patent litigations did not involve any SEPs at all. So more than half in the US didn't involve any SEPs. And of the 321 unique patents involved in smartphone litigation between 2005 and 2020, of those 321 cases, only 115, that's 36%, were SEPs. So you see the data shows that there isn't any explosion of litigation in the US. Litigation is actually going down. There's a very small amount of SEP litigation, as you can see in the chart on the right, single digit numbers. And those numbers actually are trending in a downward direction also. So we can move forward, I think, to the next slide now. And I'd like to mention the need for intervention to ensure this balance that I think is so important. Both SEP innovators and licensees, licensors and licensees, need to be held accountable for conduct themselves, to conduct themselves reasonably and with proper urgency in SEP licensing. Offers and counteroffers on both sides need to be sensible. Patent pools have been seen as a source of collaborative efficiencies, facilitating access to useful technology. So patent pools seem to be at least a partial solution to the need for sensible discussions back and forth. These pools offer an attractive way to be a clearinghouse, in effect, of licensing transactions for both patent owners and licensees. A successful example in the automotive industry, of course, Avanci is a cellular SEP pool that operates around the automotive industry, containing patents from more than 36 patent holders and providing a one-stop licensing option for automakers, which the US DOJ approved in July of 2020 with a business review letter, so-called comfort letter. Various countries have also provided helpful guidance, as we know. Japan, Commissioner Mori talked about that earlier, the ECJ led by Germany, especially the German courts, as has already been discussed. These guidelines are all practical and balanced, and they're charging both sides equally, taking a results-oriented approach, all of which is very good, and I believe they've had a positive impact. They show that there's a need for flexibility. Positive results occur when both parties, both sides, have the right incentives to come to the table, and the burden of seeking a license cannot solely lie on the shoulders of either party, the licensor or the licensee. And that's why I feel flexibility in these guidelines leads to a positive negotiating environment. In other words, the guidelines need not be too prescriptive and not be too constraining on the parties. The US, unfortunately, hasn't yet taken the same route as Japan and Europe, both of which I think have done a good job. But there are a couple of policy statements that have been issued. The 2013 policy statement and the revision of the US policy statement in 2019. These statements echo the concept that if an SEP is infringed, the patent owner doesn't lose the right to seek redress simply because the patented technology is important enough to be included in a standard. And of course, as has been mentioned, there are discussions underway now in the US concerning whether a new update is needed based on what I would call alleged difficult licensing disputes delaying standardized products. Of course, as I've already shown with data, there aren't a huge number of license disputes in the US, and litigation is not out of control in this regard. However, there is this new discussion, despite that there's no new data, there's discussion about making further changes in the US. I note that the recent letter to the US Department of Justice by 3 senators, Marco Rubio of Florida, Tom Cotton of Arkansas, and Tom Tillis of North Carolina, points out, I think, quite persuasively and correctly the difficulties and the challenges and the negative aspects of making a change to the U.S. policy at a time when there's no data showing that that's needed. So if we move to the next slide, to mention just a few points here, the underlying issues to address to restore SEP licensor-licensee balance are really just a few. First of all, we need to recognize that SEPs are a core component of licensees' products, and industries like telecommunications have taken advantage of them, leading to more and more big players being involved now, including the automotive industry, seeking to deploy these technologies to improve their products. As we know, with the development of LTE and 5G, there's been a huge increase in the compute power of automobiles, with SEPs in the field playing a key role. The licensees benefit dramatically from technology, in this case, that they frankly played no role in developing, right, or creating, with the licensors being compensated actually only for a very small fraction of the value they generate. And I'll give you an example. In the auto industry, the reality of current licensing is that licensors recoup a tiny percentage of the key functionality they provide. The Avanci licensing program is a good example. The cost of a license under the Avanci licensing program, which is nearly all of the SEPs that are needed, all the big company SEPs, ranges from $3 to a maximum of $15 for 4G capability per vehicle, $15 maximum per vehicle. This is less than the price of a car wash here in the US. At this level, if the auto manufacturers feel that they're being treated unfairly, they really need to answer a question, which is what amount less than $15 would be fair? Is there anything above zero that would be fair to pay for access to 4G and now 5G technology? And of course, there's been even more recent Avanci licensing deals, including one with GM here in the US, that shows that these pools work effectively. There's also the power dynamics in SEP negotiations. The burden is normally put on SEP licensors, appropriately so, I think, initially, to put out non-discriminatory licensing charges. Well, most SEP licensors actually publish rate cards. So coming back to the comment that was made earlier about lack of transparency, there actually is tremendous transparency already with licensors, most SEP licensors publishing rate cards and agreeing to grant licenses at those published rates. Now, licensees, on the other hand, in many cases, some of the world's richest, largest, and most sophisticated companies frequently make no effort at all proactively to put licenses in place. In fact, that's usually the case, and simply infringe and wait for SEP owners to track them down. This is a dynamic that I hope will change with the guidelines that the guidance the JPO is working on, and guidelines that have been put out in Europe, as we've discussed already. So there is an important dynamic that frankly needs to be borne in mind in terms of how these negotiations actually work. So I think we can go forward to the next slide then, and we'll try and wrap up pretty quickly here, given the shortness of time. The reality is that transparency is super important. I applaud the JPO and METI for your efforts in improving transparency in this regard. Obtaining the necessary data to address the underlying issues relies on transparency and disclosure by both parties, licensors and licensees, involved in SEP disputes. transparency at all stages, in fact, should be encouraged, from the selection of the patent to be included in the standard, to the essentiality assessments, to the licensing terms and the rates, allowing all parties in the market as a whole to make informed decisions. And so policymakers, regulators, licensors, licensees, interest groups, all of us need to explore and advance thoughtful, balanced, data-driven approaches toward achieving SEP licensing results that are fair to all parties. Frankly, incenting licensors to invest in innovation and contribute their best technology to standards, while also incenting licensees to invest in manufacturing products incorporating these standards. And the negotiations will be facilitated with greater symmetry in information between the parties and knowledge of similar deals, including transparency around the SEPs being licensed. Lastly, I applaud the JPO and Métis again, and would comment that governments all over the world, including my own government here in the US, need to play a role in fostering the right incentives on both sides to bring the parties to the table with an appropriate sense of urgency. So thank you very much for permitting me to present today.
Thank you very much, Mr. David Kapos. Next, the initiatives on SEP in Europe. We will have a presentation from Mr. Kamil Kiljanski, Head of IPR Unit, European Commission. Mr. Kamil Kiljanski, floor is yours.
Thank you very much. I hope you can hear me. There is actually a massive thunderstorm in Brussels, so it's not that it's getting dark like in Japan, but actually weather is paying us a surprise, so hopefully this goes on. Thank you very much for the invitation, both to the JPO and Métis. This is a topic which is very high on our agenda as well. And thank you so much for arranging it. I know it's very early in the US and very late in Japan, and Europe is in the middle. And also, we also hope that metaphorically, Europe will also be in the middle in terms of the regulatory solutions for SEPs. I will give you a bit of a background without using slides in terms of the context of our regulatory review, and give you a bit of a sneak preview of the public consultation we have just closed recently. So in terms of the context, this has been on the EU agenda, if you like, from a couple of directions. One is, of course, the IP direction for which I'm responsible for. And there was a communication in 2017, and also the reform we announced, at least a regulatory review we announced in 2020 IP action plan. But of course, this is just one of the directions of inquiry. The other direction of inquiry is that of competition policy, and this has produced the Huawei, that the judgment, which is discussed so often as the most rich benchmark for the licensing negotiations, but also the competition law guidelines, the horizontal agreement guidelines touch upon it. And there's also two other dimensions where actually SEPs are being implicated in terms of European legislation, and that is the standardization. We have a standardization strategy which we adopted in 2022, which of course is also an important element for SEPs. And finally, there's also the customs enforcement, which is also another angle for SEPs. So this is a little bit the background. I will not touch upon the international one because I think it has been very eloquently presented before. Maybe I just mentioned that, of course, another element in that landscape is the 2022 WTO case against China on anti-suit injunctions, which of course is a very important development. So from our point of view, we've been trying to inform our regulatory review with the webinar series where many constituents present today gave generously their time. We have the expert report group, which is published in 2021. And we also have a line of studies related to this, like many other jurisdictions. We particularly proud of the pilot on essentiality assessment, which is very important pillar of our potential reform. So this in terms of the evidence base. Of course, the evidence base is never easy because we're talking licensing negotiations, and transparency of that is not always rich, because these are private agreements, and disclosure or subpoena of those is often difficult outside the purview of competition law enforcement, which of course makes regulatory solutions never easy. But nevertheless, we do have some information in the evidence base that we mentioned. So just to take a step back in terms of why this reform was contemplated, I think it's important to distinguish the world of mobile phones and telecommunications, which of course has been the I really apologize for the noise, but it's really pouring down here. I hope you can still hear me. The telecommunications standards were structurally a bit of a different market. Of course, this was the primary discussion of standard essential patents, and it's also paved the ground for all the principles we're discussing. But in terms of why it's different now for us, it really is about the Internet of Things. And the Internet of Things actually is bringing a very new dimension to it in the terms of numbers of players who are very numerous, who are very heterogeneous, and who are also less amenable to cross-licensing dynamics. Whereas in telecommunications, we talk few players who had patent portfolios and they were experienced in negotiating it. In IoT, and we do probably see just the tip of the iceberg, we might face a situation whereby that balance is a bit different. And I think this is really the concern which is driving the review as the kind of a key factor. And of course, some of the activity that Mr. Kapos mentioned is very interesting and very informative, but every market is a bit different. As you know, the situation in Germany in terms of injunctions, at least historically, is maybe a bit different than in the US jurisdiction. So we all have to, of course, adjust for our specific ecosystem. I think ecosystem indeed is a very excellent word that Mr. Kapos used, because this is also the path to the most optimal solution. In terms of the high-level principles of what we want to achieve, really, I mean, again, we probably share the same intention, that is to say, come up with something which is making SEP licensing more efficient and sustainable, especially precisely preempting a little bit the problems which might be coming up into Internet of Things. I mean, it is actually quite amazing to see how many resources are tied up into the debates. I do take the point that, of course, in the great scheme of things, those realities might or might not be high. That's of course a discussion which requires access to data which is on a systematic basis. But if you compare it, SEPs, to non-standard related patents as a benchmark, or to other standardization frictions, that's quite symptomatic. Then the combination of a patent, like has been said at the very beginning by the commissioner, the combination of patent and a standard, which is fundamentally two types of public policy interventions, because after all, a patent is a publicly granted monopoly and a standard is also an intervention in the market. The accumulation of those does something very powerful to a SEP. And this, of course, is the source of blessing, as Mr. Kapos explained. This is a boon to consumers, but of course, it also creates a very fragile space for strategic interaction between players, which, of course, in an ideal world, are left to their own devices, except we already have two market interventions called the standard and called the patent. And I think the industrial structure and the industrial aftermath of this might not necessarily be socially optimal if left to own devices. But I think we fully take the point that the topic is really requiring a balanced approach, which is simple predictable, and which is, of course, bipartisan, because we do cherish innovation and access equally. I mean, ideally, of course, we want to not touch the incentive to innovate by the SEP holders and allow for innovation downstream and also access for consumers. I think this balance, which is not actually different than any other IP policy territory, is very important for us. So this has to be a solution which is ticking all those boxes, which makes it, of course, very difficult, as we have seen for so many years, with different attempts never being fully sufficient, and that's why we're still discussing it in so many conferences. But I think it's really important, as also Mr. Kapos said, that this is really important to find a system which is incentive compatible. That is to say, which is something which is not a brute force of a regulator, but something which brings to the table both sides, because that's the guarantee of a system which is not requiring constant enforcement. And of course, there usually, all things being equal, a structural solution is better than a behavioral solution, if I may borrow the competition policy logic of remedies. But that's, of course, easier said than done. So that's the high level, if you like, principles of why we would like to review this. Now, to the second part of my talk, I just give you with high level a bit of a preview of the public consultation. Public consultation is something which is an obligatory element of legislation in the Union. It is actually not a quantitative survey, so I think this proviso has to be made. I mean, it's a set of questions, in this case quite numerous. I think it was well into the 2 digits, put on a web page where we have all respondents reply without necessarily stratification of who it is in terms of the optimal sampling, which is, I think, what surveys do. But nevertheless, it is very indicative, both in terms of who replies and how they reply. So this was quite a number of questions, and I think this will be duly published and discussed. But I just wanted to mention a few highlights, maybe as a background, because this is the kind of the newest development we have on our plate, which might of course be later on discussed in the process of us proceeding with potential legislation. So we essentially, 50% of those who replied, in terms of who replied, are actually companies. Often it is citizens, often it is business associations, governments, but in this case, I think more than a half were actually businesses, which is always welcome, because I think they're, of course, affected both as SEP holders and implementers. And 60% of them were actually quite large. So we didn't get that many SME replying, but I think a lot of the large businesses. In terms of countries, primarily Germany, of course, other member states of the Union. US, we got quite a few replies, and Japan, for which of course we thank them profusely. We got a very good reply from a number of replies from Japan. More than half of those companies actually are neither SEP holder nor an implementer. So I think this is not totally tainted by the often polarizing debate and replies. So we have quite a cross section of different company types in those replies. Now, of course, in some of those questions, especially on licensing, it's often quite polarized, because I think if you ask a question about hold up or hold up, it almost is balanced in terms of those who fully agree to a question whether current legal framework provides sufficient protection against hold up. You have basically a bit of a wash, that is to say, more or less the same amount of people fully agree and fully disagree, which just shows limits to that type of course, public consultation. And on a holdout, almost the same, although a large chunk of people, 27%, actually fully agreed that the current legal framework provides sufficient protections against holdout. So I think there is a bit of a difference, but again, that could be related to the composition of the respondents. So I'm not drawing any conclusions from it more than, of course, this is a very polarizing question. But quite a significant majority respondents do comment that the current regime puts startups and SMEs more generally at a competitive disadvantage. So this is something which, of course, is very important for us, because a lot of what we do is calibrated towards the protection of those who might not have the deep pockets and the skill set and access to the excellent legal advice that some of the incumbents of the debate might, and they are quite populating the Internet of Things. And I would probably want to wrap up gradually with the question, which is in a way our starting point when I talk about the structural solutions, which is about transparency and about the essentiality checks, because this is where, of course, there is the very rich Japanese experience, and that's also a solution which we putting a lot of hopes for, because many things begin with transparency, and as they say, sun is often the best sanitizer. So we do look to transparency as a hopefully solution which will eliminate some of the pressure for the more dirigist behavioral remedies to the current landscape. And they actually almost half strongly agree that there's a problem, the lack of transparency. And if you drill a little bit on what this transparency, where it's needed, not surprisingly, it's about the lack of transparency of the front royalty rate, which is 53% strongly agree that this is a problem, and slightly fewer percentages on this strong agreement that divergent court rulings are a problem, 28%, which again to some extent is a nature of life, given we have different jurisdictions and patents are territorial, but that is something which is a bit lower. And then finally, and on that I would probably conclude is that a significant number of respondents, we will of course be publishing all this so you can see for yourself exactly who said what, is the usefulness of essentiality checks. I think we have a significant majority talking about them, with important provisos, right? Because I think slightly over 20% say these would be useful, but only in an advisory fashion and no legal consequences. But then a lot actually insist on this to be a more biting solution, but also caveat this. So almost 40% said that it makes sense, but only if assessors have the required expertise and are totally independent. And that, of course, is really the crux of organizing those checks in a way which is fit for purpose and independent, and the expertise is provided so that they are really having a commitment value, and they're having a value for both sides of the debate. So I think I'll stop on that note. Thank you a lot for the invitation. We will be publishing those, of course, in due time. We extremely grateful for the JPO and METI for this debate, and we definitely need to be comparing notes across jurisdictions on what we do, because it is a global issue. Whether it's a problem, of course, as Mr. Kapos said, this depends on the perspective, but whatever we do makes sense to do it in a synchronized fashion, because standards have the scale effect of being of global use, and I think it's really important that we do something which is globally coherent, and that's why conferences like this are extremely valuable. So with this, thanks so much. Apologies for the storm. The storm is gone, perfectly timed, but over to you, and thank you very much.
Thank you very much, Mr. Camille. So you said that you were experiencing a storm. Thank you very much for your time. And moving on to the panel discussion. So the theme is looking at the impact of the rulings in various countries on the licensing negotiation practice. Please turn on, may I ask to turn on the cameras for the panelists? And I'd like to invite the moderator, Professor Tamura from Tokyo University, to serve as the moderator for today. Thank you very much for the introduction. I am Tamura from University of Tokyo. Nice to meet you all. So at JPO, we are now trying to inviting opinions on the revision of the guideline for this. So now we would like to understand how the impact of the rulings in various countries are affecting the license negotiation practice. So we would like the panelists to discuss focusing on the revision point of the guide. Firstly, we would like to ask all the panelists to briefly introduce yourself. So can we invite Ms. Evelina Kogonite to briefly introduce yourself? Ms. Evelina?
First of all, many thanks for inviting me to share some points on behalf of industry that I represent. And that is in my capacity as the Secretary General of the Fair Standards Alliance. And the FSA represents a very broad area of businesses, large and small, from a variety of sectors and different parts of the world, including from Japan. And one of the earlier speakers referred to SEP innovators and licensees. And I just want to stress that FSA members contribute trillions with a T to the global economy and invest immense resources into R&D. Some of the members invest as much as a third or even more of their total revenues into innovation. And as a result, obviously, they also hold significant patent portfolios across different technologies people of today rely on. And FSA membership also participates in standardization, and many of our members do hold SEPs as well.
Thank you very much for your introduction. So may we invite Mr. Nagasawa? Can you hear me? Yes, we do. This is Nagasawa speaking. So I am from Canon, and I have been working for about 10 years in charge of intellectual property, and I have been working as chairman advocate and also working as a chairman of the IP association. So I also am working in the study group for this guideline at METI. So today I would like to deliver you what is actually happening on site when we discuss these matters, and how it is related with the guidelines and how it is related with the court rulings from various countries. So I would like to share my experience as much as I can today so that you can have a smoother negotiation. That is why I'm here tonight. Nice to meet you all. So maybe invite Ms. Lee next. This is Kodan Lee from SIMBZP, Japan. Nice to meet you all. SIMBZP, Japan is an affiliate of Sharp, and the operation of IP in Sharp is being entrusted to us. And Sharp is a rights owner of SEP and also an implementer as well. So my side, I am engaged in the actual businesses. So today I want to share what I have been experienced together with you. Thank you very much. Thank you very much, Ms. Lee. So we'd like to introduce Mr. Suzuki. So hello, this is Suzuki. I work at Nagoya University, and I am in charge of the intellectual property law. So this SEP issue I have been interested in from quite a while ago. And this time JPU is going to formulate the guideline, and I have been giving advices together with Professor Tamura in the study group. Nice to meet you all. Thank you very much. And last but not least, may we have Mr. Sabatini? Mr. Sabatini, would you please mute yourself? Mr. Sabatini, can you hear me? Would you please mute yourself and kindly introduce yourself? Mr. Sabatini, hello. Mr. Sabatini, have you unmuted yourself? I'm sorry, I cannot hear you. Is it possible to contact Mr. Sabatini from JPO side? So we'll try to do so. So due to time constraints, we would like to proceed further. I'm sorry for this matter. So we would like to come back to Mr. Sabatini later on, and we would like to move on to the discussion part. So we would like to understand the impact of the rulings in various countries on the licensing negotiation practices. And we have heard some cases, and the ruling on CISFL versus HIR rendered by the German Federal Supreme Court in 2020 gained significant attention. And at the ruling, so the notification at the stage of offering license negotiation or alerting of infringement, it will be sufficient for the SEP holders to designate the patent and to identify the infringing action. And the court stated that as an information provided by SEP holder, claim chart is sufficient but not mandatory. So we would like to ask the panelists, this is the first question. So this was the ruling rendered by the German court, but actually in the practice of licensing negotiation, how are the claim charts being handled? We would like to learn from your experience. So first, we would like to invite Mr. Matteo, but so that is, so Mr. Matteo Sabatini, Mr. Sabatini, so I think the audio problem is not yet solved, so I would like to change the order, but first, we would like to invite Ms. Krogonite to speak first.
Can you hear me okay? Good. Well, first of all, I wish to take this opportunity to compliment the GPO on the work they have done on putting together this revised draft. I think it's also commendable that they make it very clear that this recently issued draft update is not intended to be prescriptive, and that they generally keep the guidelines consistent with the approach that was established with the 2018 guidelines. So just wanted to start off with that. Now, moving on to claim charts, and I have to make the same caveat as Mr. Kiliansky because the storm is back and there is a bit of thunderstorm, thunder in the background. So just in case you might be wondering what's the noise. Claim charts. So I noted with interest that JPO appears to be referring to case law by European courts in its draft guide and relatedly in this question as well. The moderator just cited one case in Germany, but I think it may be worthwhile to consider good practices in other jurisdictions that have significant patent litigation experience, including in SEP licensing disputes. And look, I'm not a US attorney, but I understand from my members that it is a very normal practice actually to provide claim charts in patent licensing negotiations. And perhaps more importantly, that it is an initial step required by district courts for opening a patent litigation proceeding. And in US litigation, the courts generally require that the patent owner provide its claim charts, usually called preliminary infringement contentions or PICs, at the very start of the case. And I understand that a patent holder asserting patent infringement will be required to make the disclosure of PICs to all relevant parties as early as ahead of the initial case management hearing. And this is required for SEPs as well. In other words, SEP holders must provide claim charts that show at least the correspondence between the patent claim elements and the standard specification. What we also think is important is to stress that claim charts should not be made contingent on signing an overly broad non-discriminatory agreement, an NDA. And while the parties may voluntarily agree to appropriate confidentiality limitations in an NDA, due to the inherent information asymmetries in SEP licensing, any such NDA must not be the product of coercion, and nor must it be a condition for a FRAND license negotiation. And to be honest, we believe that it is entirely against the very spirit of good faith negotiation if SEP holders are allowed to effectively force potential licensees to accepting secrecy as a condition for obtaining a license on FRAND terms. And claim charts is one of the key information elements that should not be made contingent on an NDA being signed. Now, returning to the example of patent litigation in the US, claim charts are usually not filed in the case, but instead are served on the defendant. They do not depend on discovery, and as such are generally not confidential or otherwise subject to the protective order. In other words, the materials are not published in the case, but the defendant would be free to share them with third parties if they wanted to. And it is also commonly the case that parties simply include claim charts with their initial complaint as a voluntary matter. In other words, it is very well recognized in US litigation, claim charts are not confidential. I was given 2 minutes, so I'll stop there.
Thank you very much for your very clear explanation. So next, we would like to invite Ms. Lee. So in this ruling, so it says that it is sufficient, but it is mandatory. So while in practice, we have argued this matter a lot. Actually, in SHARP, what we do at SHARP is, in practice, so from the perspective as a rights holder, the portfolio, the value of the portfolio we own, the counterpart need to evaluate our portfolio value, and we would like to proceed earlier with what kind of sort of royalty will be generated. So from the onset, we will provide the claim chart from the negotiation. That is what we are doing at the current operation. So for more than 10 or so years, we have some engineers, and we're always applying for file, so for patent. So we are creating a portfolio and making claim charts. So this is not an extra work for us, actually. And for each SEP, essentiality and validity for each SEP, because we, so the judgment level might be different among the parties, and it might lead to a prolonged sort of negotiation. In order to avoid that, we need to show the claim chart at the onset and have to have a common understanding by both parties. So by doing so, we want to have a good faith in showing the claim chart at onset to expedite the negotiation process. So now can we have Mr. Nagasawa? So I think I'm just following what everybody have mentioned. So one in practice, this SEP patents, there are numerous SEPs out there. So if you just go into litigation, it would be so troublesome. So we want to avoid litigation as much as possible. And we want to expedite the negotiations as much as possible. And we want to sort of make our engineers focus on their original job, that is innovation. That is our basic idea. So as a rights holder, when claiming a patent or SEPs, naturally, we have to check internally that it is really a SEP before going on to the negotiation. So at that point, we already have some kind of a claim chart. So when we do not have, we do not need more time to create another claim chart. But if we just put in more details, then we might refer to some non-public information as well. So we will just specify that the specification number of something would correspond to this element of the claim chart. So we make something simple, and maybe about 5 or 6 will be providing charts. If we have 100 cases, providing all 100 will be so cumbersome, and the negotiation process will be elongated. So we often provide the claim charts with a clear SEP element. And so when we are, and if we just say that it is a FRAND declared announced, it might be difficult for the implementers to understand whether it is really a SEP under the FRAND encumbered stamp. So the right holders, when we are on the implementing side, we understand we always ask the right holders to provide some kind of a claim chart for us. And to accelerate the negotiation process, this is very important for us. So the German court ruling said that the providing of claim chart is not mandatory, but at our company we do provide them. And when we are on the user side, other companies did not refuse providing us the claim charts. I have never experienced that. So under the FRAND claim, when thinking of a license out under FRAND terms, so in order to proceed with that, we want to move on to the licensing contract. So I think this is the necessary information to be provided. And as I have mentioned before, so there are some people who have about 1,000 patents, and we also have 3-digit patents. And if we need to cover everything, that would be a vast amount. And so the negotiation process will be so long. So we just focus on reasonable numbers. So I think it is desirable to provide a reasonable number of claim charts. And in regards of NDA, if this we have not requested an NDA. We do not have been requested NDA so much because some information might go out during the negotiation process. So the other documents provided at the negotiation, what we have spoken at the negotiation table for these matters. Sometimes we do conclude the NDA. So whether to having NDA or not at the negotiation, but targeting the claim chart and whether if the claim chart is very simple, I think having NDA for that simple claim chart, I think that would just make the process longer. So that would not help the whole process. So there are some cases that the negotiation will be concluding a separate NDA. So when we are the user side, implementer side, so sometimes we discuss that we are not using the standard. Maybe the standard is an optional thing, not a mandatory one. For example, in 5G, there are mandatory parts and optional parts, either in 5G as well. So when we say it is an optional part, and what we're doing is we do not use this function. So for this patent, for the specific patent, maybe the specification does cover, but we are not using it. So of course, naturally, the information of the product will go out naturally. So in that case, we might conclude an NDA. Thank you very much. Sorry to cut in. So Mr. Tamura. So yes, I notice about the toolbar. So we were able to contact Mr. Sabatini, and so I would like to invite Mr. Sabatini to kindly introduce yourself and to present your opinion about this claim chart, if you please.
Can you hear me now? Can someone confirm that you can hear me? Or still nothing?
We can hear you. We can
Okay,
hear you.
that's very good. I
We can
apologize.
hear
I
you.
apologize for the technical difficulties. We've only been doing this for more than 2 years, and I still haven't learned, I guess. Allow me to briefly introduce myself. My name is Matteo Sabattini. I'm the Director of IP Policy for Ericsson. What I will say today are my opinions and thoughts. They do not represent the views of my employer nor any employee thereof. I'm sure you are aware of, Ericsson is a leader in the deployment and in the development of mobile communication since the inception of mobile telephony. We've been leading the development of 2G, 3G, 4G, and now 5G. And we have one of the strongest portfolio in the industry. As I mentioned, we are both an implementer and an innovator. And so we see this debate on both sides because we do take SAP licenses and we do license our portfolio. So going back to the question, I would like to point out that the German Federal Court of Justice found that sharing claim charts is sufficient but not mandatory. I would also note, however, that this is referred specifically to the notification of infringement. That is the very first contact with the implementer. And as far as I know, at that early stage, claim charts are shared rather rarely, not least because an NDA is not in place yet. So in my opinion, it is positive that the court acknowledges that SEP holder cannot be forced to share claim charts without sufficient measures to protect confidentiality. This key understanding can be applied also to the negotiations following the infringement notification, since the need to protect information included in claim charts is always given, irrespective of the actual status of the parties' discussions. I have to admit, I'm always surprised by the animosity around the discussion around NDAs. It is industry practice to share an NDA. It is common practice to share an NDA to protect both parties' information. And it is common practice in any commercial discussion. So I tend to disagree with some of the speakers who believe that NDAs are not used. It is, in fact, very, very common. It is the industry practice. Thank you.
Thank you very much, Mr. Sabatini. So may we have Mr. Suzuki next? So I'm actually not a practitioner, so I'd like to comment a little about the rulings from the German court. So I'd like to confirm the rulings. So this has been mentioned already. I'd like to mention 2 points. The first thing is that as an initial notice from the SEP holder, notifying of the fact of the alleged infringement based on the claim chart is sufficient as a rule, but not mandatory. The court actually said so. So basically, the practice using the claim chart, I think the court showed a positive attitude. That is my understanding. And secondly, so regarding the contents of the notice, the concerned patent and the infringement action, this information is needed. And for the latter part, the infringement part and the identifying of the infringed product is necessary. That I think I want to confirm that the court had mentioned that. So I may be diverting a little, but taking this opportunity, I would like to think about the positioning of this rendering by the German court, especially towards the Japanese audiences. What I want to mention here is that this ruling by the German court and the EU, the CJEU, for which I EG2 ruling. So this has been ruling over when the injunction will be permitted. So on the other hand, it has not directly referred to the claim of damage. So this ruling by the Supreme Court, by the German, they have mentioned a little about the damage of claim. So the implementers, that means the infringed side, they will be acknowledged of their negligence from the starting point of the negligence. So So only the damage of claim would be exceed the assumed royalty fee if the implementers will be deemed as unwilling licensee. So, and so I think all of us are aware that the claim for damage has been referred. So if the licensee is a willing licensee, the claim of damage will be within the reasonable sort of SEP implementation fee. In that sense, the comment from the German court for the damage claim is a little more stringent on the implementers than that of Japan. And that is what I wanted to point out on this occasion. Thank you very much, Mr. Suzuki, for clarifying that point. Regarding the claim chart, so I think there is a consensus on all of that the claim chart would be provided at some time. But at the study group, there were different opinions on that. So in the guideline, presenting this claim chart is normal, but we did not say that it was a mandatory thing in the guideline. So in the study group, so I'm the leader of this study group. I'm unable to speak my own opinion, but that is how it has been treated in the guideline. And there was some difference among you about the NDA. But in the guideline, we did not show any specific stance. So we just refer that NDA might be concluded. But on the other hand, the faithful negotiation guideline by METI as a norm for this faithful negotiation, so that when the rights holders should provide the claim chart, and if the implementers request for the claim chart, then the rights holder is desirable to present the claim chart without making an NDA conclusion as a condition. So the faithful negotiation guideline is going a little step further than the JPO guideline. So I think this proves the difficulty of this issue. And I think we can go on talking about this matter, but due to time constraints, we would like to move on to the next item.
Next is about the counterpart of licensing negotiation in the supply chain. Example is Continental versus Avanci and Nokia versus Daimler. There are some court decisions in the US and Europe on the subject of licensing negotiation. In case of Nokia, the final set maker said that if the set maker is entitled to have the privilege to negotiate on licenses. So I'd like to confirm the actual practice. So first, I'd like to ask Mr. Sabatini for his view. Mr. Sabatini.
Yes, thank you. So the courts have correctly identified that, especially under the ETSI IPR policy, licensing at all levels of the supply chain is not required for complying with the FRAND commitment. Access to the standard, which is the only thing guaranteed by the FRAND commitment, is granted to suppliers through so-called have-made rights, resulting from the license taken by the OEM. On the other hand, suppliers do not need an own SEP license to operate their business, especially since SEPs are not asserted at supplier level. I note that this was clearly identified recently by the US Court of Appeals of the Fifth Circuit in Continental versus Avanci. I would also point out that the success in the marketplace of Avanci, with recent news about other automotive manufacturer taking a license with Avanci, sort of proves that this is becoming industry standard and is the practice and is the offer of Avanci that is considered effective and efficient at the OEM. In any case, I want to point out that this discussion about the licensing level should not distract our attention from the important issue, which is the value of SEPs. And here we have a clear statement by courts, especially in the German connected cars dispute. For example, in the District Court of Mannheim in Nokia versus Daimler, and in the District Court of Munich in Conversant versus Daimler, that the value of SEPs must be determined based on the benefits of the technology for the end product, example, the car, and not for a component integrated into the end product. I'll stop right here. Thanks.
Thank you very much for your comment. I'd like to now ask the opinion and the view of Ms. Evelina Kolgo-Knight, please.
I think you will not be surprised that I disagree with what has just been said now. But taking a step back, I think it is really interesting that you referred to Nokia versus Daimler litigation as a case law on license availability in the value chain. And as you know, this indeed could have brought back the real legal certainty on these important questions had the Court of Justice of the EU been able to issue a preliminary ruling, including perhaps most importantly, against on whether an SEP holder can pursue exclusionary remedy and injunction against an end product manufacturer having refused licenses to all suppliers in that same value chain. Unfortunately, as you know, the Court of Justice preliminary ruling went away when a settlement happened against the threat of an injunction. As for Continental versus Avanci case, the ruling, which, as you know, has been appealed, so it remains to be seen what happens to it, was quite apparently based on errors of facts, including on the erroneous premise that Continental is not a member of ETSI, while the head of SEP sits on the board of that SEO. There are prior cases in the US that may be worthwhile recalling, where a component supplier turned to courts to get an SEP license from licensors, and it was quite effective. Licensors, including Philips and Digital, have then consequently agreed to offer licenses to u-blox in those instances. And it will also be interesting to see what comes out of a similar case in Germany, asking the court to order an SEP licensor to offer a FRAND license to a component manufacturer. And there are also collective action cases against a major SEP holder. And in those proceedings, the conduct of the actual refusal of licenses also plays a role. So, and you may have seen some news in the UK earlier this week in this respect. Now, more broadly, I disagree with Matteo. I think EU law acknowledges that the FRAND commitment creates legitimate expectations on the part of third parties that SEP holders will, in fact, grant licenses on such terms, and that a refusal to grant a FRAND license may, in principle, constitute an abuse of dominant position. And those who are familiar with EU law will recognize that this has just been a quote from the landmark case from in the SEP space in the EU, which is Huawei VZT. Now, relatedly, competition authorities, and most recently the Bundeskartellamt in Germany, have also questioned whether it is in line with competition law for an SEP holder to seek an injunction against end product manufacturers having refused a full SEP license. So not some have made, right, like lukewarm, cover up, but a real full SEP license to companies upstream that are willing to take and or seek a license. And maybe I just would also take an opportunity to recall that in Japan, METI published a guide to fair value calculation of standard essential patents for multi-component products roughly a year ago. And in that guide, it also outlines principles for calculating the fair value. And one of the core principles there in this respect is the license to all principle. So I'll stop there. Thank you.
Thank you very much for your comment. Can I ask Ms. Lee for your comment? Thank you very much. First of all, I believe that it should be left to the discretion of the SEP holder to decide to whom, in what level in the supply chain, they make licensing offer to for their own patent. Looking at the practice, So no matter which level of the supply chain the part maker is in, or whether there is a set maker who is involved in the licensing deal, we do not mind which level of the concerning party wishes to have a discussion about licensing deal. So we are open in that respect. So there are some cases where you focus on the finished set maker as a counterpart for licensing deals. The resource should be focused. We may encounter holdout a problem, and we will refer to different departments, and we end up with no progress in the discussion. Sometimes we struggle with such situations. So although there is a benefit in this negotiation, but in reality, in SHARP, we have not been so persistent in taking this approach. It's a business discussion, so we must realize a win-win situation. So if we just limit the contact point of discussion, that will limit our opportunity and possibility for the future. When there is an offer for a licensing deal, then we respond diligently for that respect. Whether it's a finished product manufacturer or the parts maker, we believe that the same rate should be applied in terms of the loyalty. We have a very complex supply situations nowadays, and this will most likely evolve further. Based on that standpoint, we should not put ourselves in more difficult situation by overly complicating the negotiation. As SHARP, we negotiate with part makers and have a licensing contract. So those cases do exist. Thank you very much. Next, Mr. Nagasawa. I believe that my response would be quite similar to Ms. Lee. Just talking about negotiation of licensing deal in general, not specific to SEP, we sell different electronic product and which incorporates semiconductor chips. There are some things that we don't really understand or understand at all. The technology and the structure, the mask pattern of the chips, what is the material used to build the circuit, those information is not known to us, so we will refer to the supplier. In case of SEP, in most of the cases, there was an instruction to comply with certain standard. You are involved in the earlier stage, so the situation is different. If it's whether it's mandatory or optional to use a certain technology, you see it on the document. We have been provided licensing rights, and then there is a special clause that oblige us to give proper information. So we talk with suppliers on certain issues. If we just rely 100% on the suppliers, we may run into some issues and we have some risk. We always consult to resolve issues. As rights holder, what we struggle sometimes is that if we just limit to parts makers or set makers, what happens is that for the things that you don't know who is a sole supplier or original supplier, it may come outside of Japan, but it may use a Japanese patent. the dealer could be the only counterpart or the party whom you can directly negotiate to, then you don't know who is the original supplier. So that will be troublesome if we were the position of the right holder. In the negotiation phase, if we were the implementers, if we receive a warning, then we give a notice. They may say that, oh, we have a license. Then it becomes more important to work out the problem with the suppliers. But one technology can come from different suppliers. If we just leave it up to the supplier, then the answer could be different, could lead to prolonged negotiation. Then we come at the front line of the negotiation. If the supplier is not well experienced in such negotiation, it could lead to worse consequence. I think it's similar to Lee-san's case. When we make a contract, the purpose or the usage of the chip, the image of the finished product should be indicated through an interview, and then that will be a reference for the pricing. So it's natural that depending on the product, the pricing could be different. If they say that they could not specify, then we would select the highest range in the rate card. Thank you very much for interesting comment. Next, Suzuki-san. I'd like to clarify. I can't hear you. Are you on mute? Well, yes, we can hear. My apologies. It's only my problem. So I'd like to clarify what I have said. I said that the German court is strict compared to Japanese court, but I was talking with the implementer in mind. So regarding the topic of licensing counterpart, regarding the conflict between the position to support license to all or access to all, legal experts and economics are divided in their opinion. Not only that, even those group of experts who support the idea of license to all are divided in their opinion about the license fee. Some insist that the same fee should be applied to all concerning parties, regardless of which level they are at in the supply chains. Others say that when parts manufacturers become licensees, the fee should reflect the value generated by the patented invention at the end of the product stage. So I'm running out of time, so I like to make a few points as from the academic side. The have-made rights or the patent indemnity clause practice is also an issue for general patent licensing. Under the Japanese law, how the legal consequence for such business practice can be evaluated do not seem to be clear enough at this point. That is why I feel that there are many challenges I need to address as a researcher. That'll be all the comment I would make for now. Thank you very much. It's true. The common approach in Japan is one point that we need to refer to. So the commonly accepted understanding is that even if it's a contract which does not involve explicitly about granting of rights, or when there is a contract which only implies the right holder's willingness to grant the license, they will be considered as granting of license. And then the patent right will be exhausted. Somewhere in the supply chain, if you say to your counterpart that we will not have a license discussion on loyalty now, once you have a finished product, then we will be able to negotiate. If you express that, then this will be considered as a granting of license, and the patent right will exhaust. That will be the legal conclusion that we can derive. There has not been enough debate on this topic, so I think that there is a more discussion needed, including the potential idea of drafting a new law.
So I would like to go to the third question. This is with regard to FRAND, and in particular, non-discriminatory. The UK Supreme Court, in the decision on Huawei, had said that trans ND is not hard-edged. We are seeing some accumulation of cases, but I would like to hear your view on FRAND terms. Firstly, from Dr. Sabatini, please.
Thank you, Tamura-san. Before I answer your question, I would like to comment on something that Evelina said, which is not surprisingly, I'm not in agreement. I found, it's a strange definition of have made right. She calls them lukewarm license. These are not hot or cold or lukewarm. Simply, the license is not needed because by virtue of have made rights, suppliers are covered by a license taken by the OEM. Another thing that sort of makes me always a little concerned is the use of the term refusal to license. There is no refusal to license. A license is offered at the OEM level. And as we discussed, by virtue of have made rights, that license allows everyone in the supply chain access to the technology. So there is no refusal at all. There is access for everyone in the supply chain. Now, with that said, let me go back to your question and the ND limb of FRAND. A similar view to the UK Supreme Court was supported also by the German Federal Court of Justice in Sisvel versus Haier. The court made clear that the ND limb does not require a most favorable licensee or a most favorable nation treatment of different licensees, and particularly that ND does not entail an obligation to offer a uniform tariff to everyone. These court decisions mirror the need for flexibility, which is immanent to FRAND licensing, and is common in different industries. FRAND terms must address very different use scenarios and can differ both over time to time and from industry to industry, as the Commission has also recognized in the 2017 SEP communication, and as Nagasawa-san was discussing. I would like to spend 30 seconds on what could happen if a uniform tariff needs to be applied to different industries, regardless of the value that the technology brings in different industries, which could be very, very different. By setting the same tariff, the same rate, we run the risk of pricing it too low in certain verticals and too high in other verticals. And I give you two examples. One could be automotive and one could be smart meters. The same rate could be too high in the smart meter vertical and therefore hinder adoption, but it could be too low in the automotive space to enhance and allow for further innovation and really to encourage further innovation in that vertical. So again, I go back to what we were discussing before about the value of the technology, which can change quite significantly across use cases. Thank you.
Thank you very much. Next, from Ms. Krogonite.
I'm sorry, there will be a tiny little bit of ping pong here unavoidably. Just to respond to Matteo's comment there, I think on refusal to license, I think it's just because all these various concepts, like FRAND in itself is a competition safeguard. So inevitably it's in the competition law that we're looking for appropriate terminology. And personally, I prefer to call it selective licensing. So, you kind of sit back and decide, well, it's going to be humongously more lucrative to license, at the end product level. So we're going to selectively not license the rest of the industry. But selective licensing doesn't necessarily exist in the antitrust scenario, just as refusal to license exists. Now, coming back to access to technology, horizontal guidelines, which is the document in Europe that actually is the basis for that language in the first place, clearly says licenses to all as opposed to access to all. And by the way, in the Court of Justice's ruling, Huawei VZT, we're also talking about licenses as opposed to access. And now, why do I call have-made rights a lukewarm solution? Is because it is not a direct license, unlike these law sources I've just quoted actually require. And without a direct license to the relevant SEPs, companies are impeded in their ability to innovate on top of standards. Models that may be claimed to serve as a substitute to actual licenses, and therefore that's why I call them lukewarm, such as have-made rights, do not alleviate competition concerns because of the narrow scope of such rights. And under have-made rights, a downstream SEP licensee can have components made by an upstream third party which is unlicensed, even if it is willing to take and actively seeks a license. However, right to have components made does not confer a license to that third party to manufacture for its own use or indeed for any other party than the instructing licensee. So what we're really looking at with this lukewarm solution is creating somewhat innovation gatekeepers. And I could carry on, but I'm just conscious of time. And therefore I'll go to the question. And there as well, I'll try to keep it short. I think it is important to recall that in that very judgment that we are talking about in the White Planet judgment, a very important aspect of non-discrimination was clarified. And the ruling is explicit in that a FRAND rate ought to be generally non-discriminatory in that it is determined primarily by the reference to the value of the patents being licensed, and has the result that all licensees who need the same kind of license will be charged the same kind of rate. And so, in other words, no discrimination issues arise so long as SEP owners offer a fair and reasonable price list available to all and refrain from adjudicating royalties based on individual licensee characteristics. And I just want to quote from that ruling: the terms and conditions on offer should be such as are generally available as a fair market price for any market participant to reflect the true value of the SEPs to which the license relates, and without adjustments depending on the individual characteristics of a particular market participant. Put it another way, there is to be a single royalty price list available to all. And by the way, that in itself implies license availability to all. And just also to stress that FRAND rate ought to be generally non-discriminatory in that it is determined primarily by reference to the value of the patents. And so not some other value that, like sometimes is a bit, kind of created a bit of a fuzzy word, considerations such as value added. It's all about the value of the actual patent. I'll stop there.
Thank you very much. I think this is really a debate that is what we would expect in a symposium. So next, Lisa. Thank you. FRAND is often discussed. We say it should be non-discriminatory, but actually we think that this should always be a general condition. However, what we mean by general condition, I might have spoken about this before, but it is not that the same rate or same amount should be applied to all licensees, But if the licensees are under the same circumstances, same business circumstances, they should be equally treated, which means that company A and company B has the same scale of business and are selling the same type of products, then the rates should be the same. If company A sells 1 million units, but if company B is selling only 100,000 units, if that is the case, whether to apply the rate or not, that should not be the case, but there should be other factors to be considered. That's how I think. Within various business, there is difference in supply chain, or there could be difference between the countries they are operating, sales scale, margin, or also if contracting among the companies in the same industry, there could be cross-licensing. So depending on the business status, contracts should be made. So considering all these status, we are working on this matter. That is the actuality. Simply speaking, even if these factors are not considered, if we come up with a certain price, that would mean unreasonable or unfair. So what would be the appropriate rate level if that were to differ significantly depending on the sector or the status? For the company, we have IP, which is for innovation. So how innovation is generated, the companies will have to make investments for that purpose. If companies were to make investments, they have certain plans, and also they have a simulation on the payback as well. So that simulation, we will have to come up with a certain situation for that purpose and come up with the next plan, how we can recover the investment. In that range, we will be working on the negotiations. That is all from me. Thank you. Thank you. Next, Nagasawa-san, please. We're running out of time, so I will try to make it short. If we were to be too strict on a hard-edged basis, at the end, this will be reflected to the license contract, so we will be losing flexibility. The SEP will have to be licensed under a single license, and if we think about the rate because of the circumstances that differ among the companies, it will be difficult to conclude a contract. As for SEP, or companies with SEP may also have non-SEP in many cases. If they want to have a license for all that, sometimes if all were to be in a strict form of contract, it could be difficult. Rather, if it is limited to SEP, that would be easier for us because we can cover the non-SEP on top of that. Simply speaking, not losing flexibility, and also the value may differ depending on the product and region. However, standard technology exists in numerous numbers, as with the number of SEP, and by using all those technologies should contribute to the industry. If we were too much excessively focusing on FRAND, it could be problematic. So basically, we will be jointly investing on R&D and be able to recover the cost, and there is a certain amount of incentive included in the rate. If that is the case, it should be okay to have different rates. However, if it is totally flexible, then that will not be SEP. The value, depending on the value, it may be possible to ask for a high price. It depends on whether the counterpart would be accepting that or not. Considering all those points, I think we should allow certain range, and that should accelerate the negotiations. Thank you. Thank you. Lastly, Professor Suzuki. Sorry, because of my operations, it seems like you could not hear me on YouTube. I think you can hear me now on YouTube. Yes, we can hear you. Okay. Thank you for confirming. As for the franc term, firstly, I believe that the franc terms accommodates a certain range. Whether license to all or access to all, how should be treated the different companies at different levels of supply chain. I would like to talk about some of the aspects that I have questions on. That is about the have-made rights. Some people are saying that the suppliers, for the suppliers, if they have the have-made rights, it should not be any, there should not be any problem because they have access to the patent, invention patent. The German court is also referring to that. But personally, I may be lacking the understanding, but this means that for the supplier, the effect of have-made rights should only be limited to allowing the use of invention under the relationship the supplier has with a certain sales counterpart. Therefore, my view is that actions to explore new sales counterparts should not be allowed. That's how we should think about when we think about the FRAND terms or relation with the competition laws. I am not yet sure about that. Maybe I'm still lacking the understanding, but that is the comment from me. Thank you. Thank you very much for your valuable comments. Actually, we are about to use up all the time that was given to us, but since everyone's here, lastly, if there's something that you want to talk about, would appreciate your comments, your final comments. I will not be nominating anyone, but if you do want to talk, please speak up.
Mura-san, if I can, maybe some very brief closing remarks on something that I've heard throughout the panel. A couple of things that I wanted to stress. The first one is we shouldn't forget the nature of patents, which are rights to exclude. It's something that we need to always keep in mind. And in the SEP context, sometimes it feels like the standard is like a toll road without toll gates, because anyone can use the standard without taking a license, without a license before they can use the standard. The second thing that I would like to point out as concluding remarks that I've heard from you, Tamura-san, is the contractual nature of the friend commitment and how the friend commitment is really a two-way street, as Huawei versus ZTE pointed out, that requires good faith on both parties. Someone referred to the friend discussions as a friend dance, right? And you need two to tango. So it's important to remind everyone that there is a friend commitment by the patent owner, but there's equally a requirement by the licensee to negotiate in good faith. Thank you.
ありがとうございます。他の方、どなたでもいかがでしょうか。
Thank you very much for your comments, Mr. Mateo. Any other comments?
Yes, just to maybe build on what Matteo said, I think it is very true. Patent is the right to exclude. But what makes SEPs special is precisely because companies get together and for all the good reasons eliminate competition amongst technologies for it to become a standard, and with that comes power, and that's why a FRAND commitment has been established and introduced. And a FRAND commitment is a competition safeguard for all the reasons why that there may be incentives to do things without market power. And maybe just another point I would like to mention just to maybe recall that in the US, there is the DOJ, PTO, and ST draft statement, and it is a very balanced approach. And I think in many ways, it sends a clear message that the current US administration does not at all endorse the New Madison approach. And for those who haven't seen, just earlier this week, the US Federal Trade Commission Chair Lina Khan and Commissioner Rebecca Kelly Slaughter made a written submission on the public interest, which clarifies, and it's on the use of injunctions in SEP context in particular, that there is a public interest in avoiding remedies that allow for opportunistic behavior, including excluding willing licensees from the market to extract super FRAND royalties, and that implementing remedies that reward such behavior undermines the very purpose of the FRAND commitment. So I just wanted to mention that. Thank you very much.
Thank you very much. I see Nagasawa-san's hand is up, so I'll be very brief. As I have mentioned in the beginning, so the SAPs are so numerous and they were creating a social infrastructure, and among that, so we need to have a culture that anybody can use it. That is the assumption. So what we can contest is validity and essentiality. I think that we can contest upon that part, but for other parts than that, we do not want more discussion points. So there was some dispute on jurisdictions, the global license and ASI, there are several things, and we have excess discussions ongoing. So if we have negotiation in the industry, things are getting more and more complicated. So I think it is not really desirable. That is what I am seeing about these ASI matters. And there are some PPUs and anti-market value. So if you fix it on one side, then it would narrow down the range of the negotiation, and sort of the confrontative structure will remain. So both sides have their own reason. So we have to discuss the matter among the interested parties, and we have to be flexible to reach a settlement at an earlier stage. I think that is the most thankful thing for the industries. In that sense, so this under Matisse guideline, I value a lot. Thank you very much. Any comments? So let me just say something here. I totally agree with what Nagasawa-san said. So the SEP discussion is now escalating significantly and having a rippling effect to the other part. So it is not just company versus company. It is getting more beyond that. So looking at the and they are not sort of achieving their original targets. So this guide on licensing negotiation, we had some sort of common grounds for discussion, but now the scope is expanding to different industries, and those different industry people do not know about SEP licensing negotiation. So having this kind of guide on license negotiation is very helpful, and in practice, we do refer to your guidelines. So I'm very thankful to JPO's effort. Thank you very much. So since everybody is commenting, can I ask Suzuki-san? As I have been engaged in, and I might be complimenting myself, but this guide is very comprehensive and very thorough and easy to understand. So I hope it could be utilized by various parties. That is what I expect. Thank you very much. So thank you very much for speaking. What I should comment. Now we're a little bit behind the scheduled time, but thank you very much for a very fruitful discussion. I had learned a lot having this kind of opportunity. So now I would like to give the microphone back to Mr. Nishina.
Thank you very much, Tamura-san and the panelists for your active discussion. And Tamura-san mentioned how active discussion made this a very lively session and the debate in a way. And apology for some of the administrative or technical issues. And please let us move on to the next topic for the panelists. The topic is essentially check in Japan in terms of efficiency for licensing. With the moderator and the panelist for panel discussion number 2, switch on the camera. I'll pass the microphone to Dr. Miyoshi Hiratsuka from the Tokyo University of Science to take it from here. Thank you for the introduction. I am Miyoshi Hiratsuka. I hope everyone can hear my voice well. Yes. So we look at the essentially check in terms of efficiency for licensing for this session. Before we start, I'd like to ask each panelist to introduce themselves. First, Endo-san from Aldage, please. I am Endo. I am the president and CEO from Aldage. We are the operator of a patent license us too for digital TV technology. I was originally from JVC. I was involved in a VHS licensing program there, and then the optical disc and the compression technology on digital TV related patent tool was an area where I was involved as a right holder. Timson Licensing had an office in Japan. I moved there. In 2018, I assumed a role as the president of Aldage. Thank you. From the position of rights holder, Mr. Fujiki from IBB Bridge. Thank you for the introduction. I am Minoru Fujiki, and I'm from IP Bridge Incorporated. Do you have your microphone on? Yes, it is unmuted. Maybe the moderator has a wrong language selected. Now I hear you. It's okay now. Thank you very much. I am Fujiki. I am the CEO of IP Bridge, and we are in the business of procurement and licensing intellectual property rights, including SEPs. We also participate in patent tool as part of our business. I believe it's a great opportunity for me to participate in this session. It's late in the hour, so I have to fight with my sleepiness, but I hope this will be a good, active discussion. If you can select a Japanese language when you speak, that would allow the listener logging to the YouTube channel to hear your voice. Thank you. Next. From Hitachi, Mr. Sato, the rights holder and implementer. I am Eijiro Sato from Hitachi. I belong to the Global Intelligence or Intellectual Property Management Headquarters. Let me talk a little bit about IP management in Hitachi. We are a global enterprise. We have a global IP strategy. The global intellectual property management headquarters has been established in beginning of May or May 2nd. The head of the headquarters is non-Japanese person. Chief Intellectual or Property Officer position has been newly established. And this person has affirmed this new role. He is based in New York, overseeing the entire global IP management activities. I am based in Tokyo. And there are parts of organization which is still dedicated to Japan, but this global headquarters oversees other areas of Asia, including China and other parts of Asia. And finally, I'd like to have Ms. Matsuyama from TMI to introduce herself. I am Matsuyama from TMI law firm. I specialize in IP contracts and litigation and various kinds of business contracting. The essentiality check for SAPs is a topic for this discussion, and on the day-to-day basis, I am involved on this topic, and I work with patent lawyers to work on this process. The patent pools and the right holder may request this checking, and there are other inquiry from other parties in the market to conduct this kind of essentiality check. Of course, with my experience, I'm limited in my ability to see the entire picture on this topic, but I'd like to learn from this session today. Let's go into the discussion now.
In this discussion, we want you to focus on the ideal status of the decision-making on the essentiality of SEP. On SEP, disputes between different industrial sectors have surfaced and various cases have been accumulating. In the previous panel, I believe many discussions were made. As was mentioned during Professor Tamura's panel discussion, as for claim charts, Sisvel versus Hayar case, where it was determined that provision of claim chart is not a must, is attracting attention. Meanwhile, as for the determination of essentiality at Japan's JPO, the operation of the system to evaluate the standard essentiality of an SEP has started, and at EU, report on the pilot study on essentiality decisions was published. And the topic is also included in the public consultation, which was done until last week. As such, the governments in various countries are discussing about the SEP essentiality. On the other hand, we would like to ask how you are working on this point in practice. I would like to ask all the panelists. So the first question, what kind of information is provided to describe SEP essentiality? And how do those information contribute to the efficiency of license negotiations? Firstly, from Mr. Endo from Audage. The patent pool that are managed by Audage, I would like to introduce about those pools. We mainly provide two types of information. The first type is the list of essential patents. And the other type is information on the determination process of essential patents. Firstly, about the essential patent list. For the decision on essentiality, all of the patent numbers and the patent holders, those information are disclosed on the website. And also for the patents that have expired, the expiration date, and also saying that the patent has expired, that is also shown on the list. or the website. One other type, which is the information on the determination process of essential patents. This includes the information on procedures to apply for being determined as essential. Some of the documents that are needed for this procedure, those are listed on our website. And the actual procedure is conducted by the Japan Intellectual Property Arbitration Center. So we provide a link URL to the Japan IP Arbitration Center. So the actual potential patent holders should be able to access this entity. And the effect of these information, what's most important is that the essential patents that we manage, all of them have been given the decision by the Japan IP Arbitration Center as being essential. For your reference, the digital TV that we are licensing, recently we are seeing 4K broadcasting. For this 4K broadcasting, now essentiality has been determined and the number of patents has exceeded 540. For all these patents, the Japan IP Arbitration Center has made a decision that they are essential. Because of this, for the holders of the essential patents, the essentiality is specifically clarified and can work on the patent negotiations. That is the advantage. And also for the implementers, all of the patents that we manage have been given the decision as being essential from a third party. That will give them comfort. And with that, they should be able to obtain the license based on those comforts. Thank you. Thank you. Next, Mr. Fujiki from IP Bridge. Thank you. At the time of the negotiation regarding the information to be provided on the essentiality of SEP, based on my actual experience and the practical aspects, basically among the negotiating parties, should be discussing about the essentiality and aim for solution. I think that is extremely important. And the valuation of the essentiality should at the end relate to the rate of the SEP or the risk of winning or losing in future litigations. It should be relevant to have discussions. So I believe that the right holders, in order to achieve that purpose, they are providing information, including claim charts primarily. As already mentioned from our standpoint, in order to facilitate the negotiation, the implementer should be able to understand the contents should be quite straightforward to a certain extent, not just a number, but by phrase or by word in the claim, or showing how it relates to each element. I believe that we are seeing many cases showing them. Also, as to the timing of providing the information, as was discussed in the previous panel, showing claim chart at the initial notification stage, that is rarely the case. The provision of the claim chart should substantially be the start of the negotiation. Basically, at the onset, the claim chart are provided. I think that's preferable as well. And in that case, in the claim chart, not just public data or public information, but to a certain extent, the interpretation of the rights or legal interpretation, those could be included in the claim chart. And as being at the starting point of the negotiation, to make the negotiation, to facilitate the negotiation, entering into an NDA and starting, that could be common on a practical basis. Actually, there had been some expressions that is different as expressed by Meti. I am a bit surprised for that, but probably the prerequisite for the claim chart, definition, etc., could be a bit different. But I do think that NDA is a must to start the negotiation. And also whether it is useful or not. For the implementer side, for both sides to work on the negotiation on the license to reach a conclusion, if both have the intention for that purpose, this tool should be very useful. The claim chart should be very useful. On the other hand, if the implementer side, for example, do not have much willingness to proceed with the negotiation, no matter what kind of claim charts are shown, it should not be helpful. That is all for me. Thank you. Thank you. By phrase or by word in the claim, showing how it maps to the standard elements. To me, that was indeed impressive. Next, from Mr. Sato of Hitachi. Firstly, what kind of information is provided on the on that? Actually, I first want to say that Hitachi can be on both sides, either the right holders or the implementers. I believe the same applies to many electronic companies in Japan. Today's panel, Hitachi could be viewed as the representative of the right holders, but I would like to stress that it is important both from the right holders' perspective and the implementers' standpoint. So firstly, what kind of information is provided on essentiality? I believe that there could be various levels. Like for example, talking about the licensing of a tool, if, for example, the licensor and licensee are in the same or adjacent industrial sector and the contents is quite straightforward, there could be cases that the pool's essentiality is certified and in many cases would not lead to any disputes. On the other hand, this could happen in individual negotiations, but there could be cases where the contents provided are not straightforward. There could be cases like that. So I would like to talk about some typical 3 cases. The first point is, as was discussed in the first panel discussion, the issue of claim chart. The claim chart only just announcing or committing to the standard setting organization about its essentiality, starting the negotiation just based on that commitment or announcement, that could be the case. It is not that if it is regarded, if it is related to the standard element and saying that it should be essential because of that. If the negotiation starts like that, I think it should be the case that the essentiality should be first determined by a third party. And the second point is that whether even if a claim chart were presented, it may not necessarily be essential in relation to the standards element. For example, it can only be an option for the standards element, or the standards element specifying the functionality the patent claim may only show one of the multiple ways to realize the functionality. In some cases, it could be covered, in some cases not. And in that case, the connection between the two, if that is not shown in a straightforward manner and saying that it is essential, that could happen in actual cases. Information that is not easy to understand should be disturbing smooth negotiation. It should clarify that it covers A but does not cover B. Those should be shown in a logical manner. That is what I think is needed. And the third point is, as had been discussed, even showing a claim chart, it could be cases that the claim chart indicates essentiality only those related to the representative patent, and the essentiality of patents other than the representative patent can go out of the scope of the discussion. In some cases, people say that they should show the claim charts of everything, but some people say that the claim chart for the representative patent should be enough. In some cases, the royalty can be calculated by multiplying with the number of patents. The value to be calculated in that approach, that will not be convincing the implementer side, and also for the patent right holder side. If those that are not essential are included, it should obstruct the distribution of proper compensation to the patents that have fully contributed to the standard element. So I think this is a difficult issue, but like, for example, the essentiality, if that is not clearly shown or given, then the calculation of the value should be done in a different way. I think that should be promoted. Those are the 3 points that I have mentioned. Thank you. Thank you, Sato-san. I'm not sure whether we can call this an issue of option, but there could be some cases where the patents that are not related to the standard element could be included. It may happen to be so or intentionally done so. That might be meaning that the sincerity is quite questionable. I would think it that way. Next, Matsuyama-san, Ms. Matsuyama, please. What I want to say may be similar to what other people said, but at the time of the negotiation, I do think that you should show the claim charts. The party asserting the right in order to show the rationale. I believe that claim chart describes the most about the rationale. Here, comparing the standard element and the patent, by using this comparison, if that is the case, claim chart should be used to show the essentiality, and I do believe that we should show the claim chart should be shown. But in actuality, as was discussed during the previous panel, we are not showing all of the claim charts for all of the patents at the time of the negotiation. In actuality, we're showing those that should be valuable for the progress of the negotiation. In actuality, I am asked to select which claim charts are useful. So I do believe that on a practical basis, showing all of the claim charts is not practical. When we say about essential patent, some of them may have all of the patents being determined as essential, but in some cases, there could be cases where the patents may include those that are not essential. If you're calling this as essential patent, independent, neutral third party should at minimum be deciding about the essentiality. With their endorsement, with some minimum endorsement showing that the representative patent is this, and looking at the value by multiplying with the number of patents, I think that is what we should be heading for. That's my impression. And as I conduct some appraisal or assessment, as Sato-san mentioned, there could be cases where the standard element itself is written in a selective manner. It may not be so often, but we do see those cases. When I am asked for appraisal of those, if thinking about the structure A, then this patent is essential, but for B, this may not be essential. So those are patents that could become essential on a selective basis. This should be positioned in a different manner. That's my understanding. But when we create these opinions by being asked from the patent pool, whether it is when negotiating with those people who may have difference in the understanding of the license, whether the patent is truly essential or selectively essential, those information should also be disclosed at the time of the posting of the patent list. If that is the case, I believe that will be the foundation for conducting a better negotiation in good faith. Thank you, Ms. Matsuyama. I believe from different perspectives, you have mentioned about the essentiality of SEP. Of course, the essentiality information is important, but on the other hand, how to obtain the information on essentiality, there should be various approaches.
So in practice, the essentiality will be determined in various manners. Then, in what mechanism essentiality should be determined? And from the rights holders and implementers, how this mechanism should be utilized? So we would like to hear first from Endo-san from Aldage. So this is also an example from my company, Aldage. So regarding the essentiality, the right holders and implementers, and Aldage, like us, the patent pool operating company, is concerned parties. We need some third party, independent neutral third party that should carry out the determination. I think that is the ideal way. By doing so, an arbitrary decision could be eliminated. So it's a true, fair, and just positioned decision could be made. And I think that is very crucial. In that case, still technical elements and legal aspect, interpretation of the patent, these matters should be carefully carried out. We need to select a third party that can handle these matters properly. So for us, lawyers and patent attorneys, the group, we ask Japan IP Arbitration Center, a group of these patent attorneys and attorneys, to judge the essentiality of the patents. But as I have mentioned, the number of patents that we handle, the determination of a huge amount of patents sometimes come in from other rights holders. We have these cases sometimes, and we need to ensure certain resources to handle these processes. And having multiple judging person, we need to have a leveled judgment. So we have to be mindful about that we deliver a same level determination when assessing essentiality. So in this Japan IP Arbitration Center, they are carrying out a periodic training course so that the evaluation standard would be sort of unwavering and established. And as a result of the actual judgment, as I have mentioned earlier, and we are presenting a patent list. And as has been discussed from before, so for the something like claim chart, we do not disclose that. But one reason for not doing that is this company Aldage of Fuss is a neutral position with our relationship with our rights holders and implementers. So the exchange about this essentiality should be among the decision-making body and the rights holders. So we only receive the results in our company. That is what we are doing. So from the implementers, sometimes they request a claim chart. This is not frequent, but it is not zero. In that case, unlike individual license negotiation at our patent pool, as I'm reiterating, all patents have been gone under the essentiality judgment of the third party. So based on that, we do not provide claim charts. And we are having the contract concluded by having that point understood. So this is my personal observation, but in individual negotiation, if we prepare claim charts and have a discussion based on the claim charts, then as a result, the implementers will. I think it is difficult for the implementers to smoothly accept the claim on the right holder side. Usually they say this patent is not essential. We're not using this aspect. So between the implementers and the right holders, how to find a common ground, having a third-party appraisal, third-party appraised patent, then then there need not be a discussion between these both parties and see a sort of a common ground, a settlement. I think that is possible. So having an independent third party rendering the essentiality appraisal from a neutral standpoint is very important. Thank you very much. So the one point is the resource of the arbitration center. That could be one point. But since we are quite due to time constraints, we would like to hear from Mr. Fujiki from IP Bridge. Thank you very much. I have a different point of view. So talking about essentiality, it could be about a license negotiation, a licensing contract. So these will be waiting ahead. So as has been discussed at the previous panel discussion, the license has quite a certain range. So the concerned parties have their own circumstances. So thinking about the different circumstances, the purpose of the concerned parties, having a unified system, I doubt if it would be workable. I'm doubtful about that. So we have negotiations with many companies, and we have seen some settlements or resolution, and there are ongoing negotiations as well. But for depending on each company's purpose and circumstances, we are responding, or we might utilize a patent pool, and we can do the licensing utilizing this patent pool. So each time we are taking into consideration each circumstances and try to seek a solution. And the standardization is ongoing and the market is expanding. So in the I do not think if there is a significant problem under the current situation for part of the implementers, just focusing on the part of the implementers and the rights holders. I think we have to look at the whole society and the whole industries, and we have to discuss whether this kind of discussion is really necessary. And regarding the patent pool, so at an outage of Mr. Endo and the video compression pool. For this standard, both implementers and rights holders are in favor of that pool, and it is being operated very well. So because they are in favor of that pool, they follow the rule of that specific pool, and the level of the essentiality determination is being shared among the members. But sometimes that is not the case for every patent pool. So it does not necessarily mean that the patent pool does not carry out the determination of the essentiality is not carried out properly. They do utilize outside lawyers and patent attorneys to decide the essentiality, but sometimes there are people out there who are not convinced with the essentiality, and so that the patent pool is not working properly. So even the essentiality approved by a certain patent pool, it does not lead to having no dispute among the concerned parties. Unfortunately, although even the patent has been determined as SEP, we have some SEPs that have been contested in the court proceedings. So even having this essentiality determination, the negotiation on the important part, sometimes we have to sort of fight looking at the other elements as well. Under such circumstance, I think we need to discuss whether it is really necessary or not. So this essentiality appraisal needs money. I think you need about a few 100,000 to 1 million. So if you can receive a merit that is proportionate to that cost, and who is going to benefit from that merit, and who is going to bear that cost, and maybe the rights holder should bear that, or the implementer should bear that cost. There may be various talks. If the right holders just have to bear that, they would stop investing for innovation. And if the implementers have to bear them, and the final users have to pay for that in some way or other, then it will might hinder the dissemination of the standard. So in that case, maybe the implementers would not seek for real essentiality appraisal. So we need to look at the overall structure and think of a good timing to move forward. I think that is the realistic way of thinking. I think that's about it from my side. So today's topic was more focused on creating a mechanism. My idea is if the administration, should handle not just the essentiality evaluation, but they have to focus on moving forward innovation. So high quality standardization activities, and they have to support the pushing forward innovation. So if there is a violation of antitrust law, they have to check these kind of actions. So this essentiality evaluation part, to be frank, I think myself do not think it's a high priority. Thank you very much. So next, we would like to invite Mr. Sato from Hitachi. Thank you very much. So how this essentiality will be decided? So I would like to point out 3 things. The one thing is, just as Mr. Endo mentioned, it's a decision-making body. So it's better to have a specialized entity to make that decision. And that party needs to be a neutral party without any interest to make the decision. That is the ideal way. The pool is one of that. And so we can request the law firm to do the essentiality determination. I think that is one way to do it. Of course, from a neutral point of view, they can make that kind of decision. But sometimes they render a decision that is more favorable to the client. That is what sometimes I hear that. So in order to determine the essentiality in a proper way, we need to have a specialized party with a neutral standpoint. In JPO, they have a judging system for essentiality, and this is very meaningful, even from a global perspective. So because they're highly specialized, they are neutral, they could be trusted. So having JPO make the judgment is really helpful. The second thing is about applicants. So the right holders and implementers from both sides. The idea is to enable both sides can easily apply for essentiality judgment, especially from the right holders or implementers. Sometimes we want a system if we can have a single application, make a single application from either side. So before starting the negotiation, if they can have an explanation about a reliable third party, they can make necessary preparation before the actual negotiation. And the rights holders can confirm the nature of the patent, so the negotiation could proceed smoothly. And claim chart being made just by representative patent, that has been mentioned. From the implementer side, regarding non-SEP, maybe there is no essentiality. If the implementers think that way, by making a single application, if there is essentiality or not, if that could be judged properly, then this will also help to proceed with the negotiation in a smooth manner. In that sense, in the existing system, when requesting from one side, the Japan IPR Arbitration Center would be in charge of that. So the scale and the number of cases treated, we want a system that we could use easily. And if there's a difference in opinions, of course, we can use the judgment system provided by JPO. And we want to utilize further this JPO's judgment system as well. And third thing is, when making a judgment on essentiality, if we can have a mechanism to assess the validity at the same time, it would be much better. As I have mentioned earlier, so among the SEP declared patent, there are some doubtful ones in terms of the essentiality. At the same time, sometimes there are some doubtful aspects in terms of validity as well. That is a reality. So for SEPs, the rights holders and the implementers, in order to have a solution that is convincing to both sides, we need to have a neutral party to determine on both the essentiality and the validity. So by one single procedure, if the same entity can deliver the decision on two aspects, I think that would be desirable. That is all from me. Thank you very much. Thank you very much. So based on that, you'd like to hear from Ms. Matsuyama. When deciding on the essentiality, whether it is necessary or not, that has been mentioned as well. So if the essentiality is being decided or not, then no problem would arise. That is not necessarily. Of course, there might be some dispute further going forward. But since we have to handle a lot of patents, we need to have a certain sort of a credential if a certain patent is called SEPs. And so basically, we need some specialized party, a neutral party, to make the decision. So we need to have the implementers be convinced from an objective point of view that if that party had admitted that essentiality, then we can rely on that. So in that sense, the JPO's judgment system, there are some difficulty in using that because there are certain conditions for usage, but also the Japan IP Arbitration Center judgment is also being used quite a lot. So what I've been actually experienced through my practice, so when requested from a patent pool, the Japanese patents applied to that patent pool shall be judged at our office, and the judgment for US patents will be done at a specific US office. So from that specific patent pool, they are sort of they are assigned to us in terms of all the Japanese patents. So we have some teams, attorneys and patent attorneys. We try to align our opinions. So we try to level our decisions. That is what we are being careful about. And it's been pointed out. So whether we do look neutral from the outside, we sometimes have a little doubt because being an attorney, we have to work for the benefit for our clients. So when the right holders make requests for us, maybe we do render some decisions a little favorable to the clients. But in terms of the request from the patent pool, of course, they do not want to have a dubious SEPs within their SEP portfolio. So there might be anti-price related matters arising. So I think the patent pool wishes us to make a correct decision whether what is SEP or not. So in that sense, we do not make any sort of favorable decision. We just carefully select what should be called a real SEP or not. So that is what we're doing. So that is what the patent office and the law office are doing. So to have everybody, all concerned parties be convinced, we need to look really neutral from the outside. And deciding on the validity, maybe I do not have much experience, but we do not go that far. We just finish by doing the essentiality determination. That is my impression. But usually if the litigation for patent infringement, the validity and the sufficientness will be always checked. So from my experience in a patent lawsuit, there are some cases that the validity is not being approved. So I don't know whether essentiality comes first or it can done in parallel, but ideally both essentiality and validity could be judged at the same by the same entity. I think this is what we should aim for. That is all from my side. Thank you very much, Ms. Matsuyama. So essentiality judgment that is binding for all will be difficult to establish. That was one voice. But establishing a mechanism for making a decision, then having a neutral third party would be ideal. I think that was the overall opinion from the panelists. And at JPO, they have a judging system, and this is quite valuable even from a global perspective. So this decision system by the JPO is being published and has an authority. And also at EU, the word, I think the word judgment is being used. So I thought we had more time, but actually it's already 10 o'clock in the evening. But we just don't want to just finish right away, but we want to invite some comments, and if you wish to make any. So we would like to ask for your comments. So let's start from Endo-san.
So if there's anything that you want to say before we close, you're invited to share your ideas. There was one point which other people mentioned, but I didn't mention. One is about validity, how to deal with that. So why are we talking about essentiality? Currently, there's no established party who is dedicated for the checking, but for the validity, the patent office can confirm officially in the application process, and that is validated by this government body. Whether there is another round of evaluation necessary, we should be cautious whether that is really necessary. There's another point about options. So depending on the scope of the implementers, the answer might be different. In case of patent pool for digital TV, the broadcasters who broadcast programs, and then there is a set maker who manufactures receivers. Thinking about the standards, how is that option managed? For broadcasters, several options are available. It could be broadcasted in one way or the other, so they have options. However, for the receivers, regardless of which format the broadcaster uses, the receiver has to have the capability to receive either of the format. So they should comply with different options. The handling of the options and availability of options depend on which part of the market they are participating in, or business that they're in. So if you have no need to include options as part of the patent, and there will be no benefit coming from making that available. That's my point. Fujiki-san, please. Thank you very much. The key word I'd like to mention is that the SEP issues have to be taken up as a global discussion. Even if you establish a good system or policies at one locations, the fundamental problem cannot be resolved. both the right holders and implementers act and operate globally. So the discussions that is going on in the patent office and METI. So I hear that there is a meeting structure. The executive of several international patent offices get together for a regular meeting. That is a good forum, or ETI or FIGBT or standardization organization can be involved in the discussion to ultimately come up with something as a foundation. Then it will be beneficial. Thinking about the system only which is applicable for Japan, I don't think that will bring a lot of positive benefit in my view. Cross-industry approach on SAP is a common nowadays. Talent development and human development will be one key area to look at. There are many legal experts and professionals whom we can work together, not only in Japan, but in other countries in different disciplines. Patent attorneys may have a specialized field. By increasing and enhancing their capability and increasing those resources over time, then the licensing discussion and negotiation can be effectively organized. The global perspective is important, and talent development are the two key points that we need to look at in the future. I would like to end on that note. Finally, Sato-san, any comment? Thank you very much. As a closing note, what I'd like to say is that when it comes to SAP topic, necessary information depends on the position of that individual or entity in the market. So we should have a tailored approach when it comes to the provision of information. I'm not going to debate on what Fujiki-san has said. I think the last time we met was when we were in San Francisco. It's been a while. We meet NDA. Is it necessary to share claim chart or not? Depending on the counterpart, the necessity for non-disclosure agreement may change. The license cannot be granted unless you have a thorough discussion with the counterpart based on the relationship or the circumstances that you are in with those potential partners or the contracting party. It cannot be standardized. And we have to also think in relation to the standards. So the spirit of setting up the technical standard is to share the valuable invention or innovation together in the group. Decision is made, and once things start moving, we cannot result to alternative route immediately. Some parties are not good at negotiations. So there'll be strong players and not so strong players. It is important that you make sure that your counterpart has sufficient information and is convinced to move the discussion. Some parties may be reluctant to share information without the non-disclosure agreement. So the spirit of coming up with a group is to come up with a common standard that can be utilized with a large number of people. the information should be widely disseminated. I wonder that the NDA will be the sole solution or the only solution that we should have for everyone. We should have a decision so that any party interested in taking advantage of this patent can get the fair offer, whether or not they excel in negotiation skills or not. I think that is in line with the spirit of standardization. Thank you. Finally, Matsuyama-san, there is not really one point that I like to stress here. I realize once again how diverse opinion can be when it comes to the topic of SEPs. So SAP is very unique in nature when we think about the spirit of making a standard which is intended for widespread use for the right holder in order to get the license fee income. It will make sense to have the right essentiality check to ensure the rights to the best of what is available. So I think it's a very important topic to further discuss. Thank you very much for your comment, and we have run out of time already. SAP can develop a lot of discussions. Just taking this topic of essentiality evaluations, there was so much to discuss. I hope that based on the discussion today, although there may be some difficulty along the way, as Nagasawa-san of Canon mentioned in the first panel discussion, using the standard technology to better the society. And there's another topic about the spirit of standardization. So there are various more topics of discussion based on what we have discussed today. I hope that JPO, as well as the other competent authorities in other countries, will continue to study this topic. Thank you all for your active discussion. I'd like to return my microphone to Nishina-san, the moderator. Thank you very much. It is good that we have a very heated debate during the panel discussion. I'd like to announce the official closing of this program. It is good that we had a very variety of positions expressed on the topic of SAP that provided a lot of thinking opportunities. So this concludes the program for today. Now, I'd like to announce that there will be a questionnaire available on JPO website. Please send your feedback through our website. As our Commissioner Mori mentioned in the beginning, the draft document of the new guide is available to invite any public comment until June 8th. If you're interested in sending your comment, please refer to the outline of this public comment program and submit your comment by the due date. We will close this symposium today. Thank you all for your participation. Thank you.